Good day, I'm Carissa Marie P. Balilla, and I will be reporting in this subject, Torts and Damages under Attorney Noel S. Adion. And this is going to be the second part of this subject, which is damages. And in part 2, the scope of my report will be focusing on the general provisions of damages and Article 2195 to 2199. Now let us begin with the general provisions. The Civil Code expressly provides in Article 2195 that the provisions of this title shall be respectively applicable to all the obligations mentioned in Article 1157. And if we will be going back to this article, this should talk about the obligations arising from delict, quasi-delict, contracts, and quasi-contracts. So before we discuss the different kinds of damages and how it is being awarded, it's first important that we understand the concept of damage itself. And we will be doing this by actually exploring the different definitions provided by the legal luminaries and of course the decisions issued by our Supreme Court. And damage has been defined as the detriment, injury, or loss which are occasioned by reason of fault of another in the property or person. And also, of whatsoever nature the damage be, and from whatsoever cause it may proceed, the person who has done the injury ought to repair it by an indemnity proportionate to his fault and to the loss caused thereby. And in legal contemplation, the term damages is the sum of money the law awards or imposes as a pecuniary compensation, or in other words, it can be understood as a recompense or satisfaction for an injury done or wrong sustained as a consequence either of a breach of a contractual obligation or a tortious act. And this can be derived from the provision as provided in Article 2195, where we go back to Article 1157. That's why this would arise from a breach of a contractual obligation or a tortious act. And it's important to note that a complaint for damages is personal in nature, and we will be discussing this next. So the question now is, how are we going to institute a complaint for damages? So since we have mentioned earlier that it is a personal action following our rules on civil procedure, it may be commenced and tried where the defendant or any of the defendants resides or may be found, or where the plaintiff or any of the plaintiffs resides at the election of the plaintiff. Part of the general provisions is also understanding the difference between damages and injury. It's important that we understand the definition of each for us to further be able to explain how damages are being dealt with in accordance with our laws. Now, in the definition of injury, it is provided that it is an illegal invasion of a legal right, whereas damage is the loss, hurt, or harm which results from the injury. As a general rule, it can be understood as if the damage is the result which comes from the injury, since damages are the compensation awarded for the damage suffered. However, it must be understood that there can be damage without injury in those instances in which the loss or harm was not the result of a violation of a legal duty. And this is what we call damnum absque injuria. In the landmark case of Spouses Custodio versus Court of Appeals, the Supreme Court gave an example of damnum absque injuria. And in here, this was a case between it's about the damages that is being alleged based or out from the construction of the fences of of the owners of a particular parcel of land. And in here, the Supreme Court ruled that when the owner of property makes use thereof in the general and ordinary manner in which the property is used, such as fencing or enclosing the same, as in this case, nobody can complain of having been injured because the inconvenience arising from said use can be considered as a mere consequence of community life. So in this case, the example wherein there can be damage without injury is very much explained by our Supreme Court. In another example, taking the ruling of the Supreme Court in Saba versus Court of Appeals, the court believed that it is its duty to see to it that public officers are not hampered in the performance of their duties or in making decisions for fear of personal liability for damages due to honest mistakes. Related to such rule is the maxim qui iure suo utitur nullum damnum facit. One who exercises a right does no injury. This maxim is often applied to cases where the court rejects claims for damages of the winning defendant in a case. The court often reiterates the rule that the adverse result of an action does not per se make the action wrongful and subject the actor to payment of damages. Now, another question is, how do we pay damages? Our law provides that damages can only be paid with money, and in one case, the plaintiffs were ordered jointly and solidarily liable to defendants the quantity of 100 kavans of palay every year from 1972. Now, in this case, the Supreme Court ruled that damages can only be paid with money and not palay because palay is not a legal tender currency in the Philippines. So, it's important to note here that in actions of damages, the courts should award an amount to the winning party and not its equivalent in property. So, money only in terms of paying damages. Now let us move on to the kinds of damages. And it's important to note that the word damages involve any and all manifestations of life. And if we will be talking about this should involve physical or material, which is what we commonly know about damages. And it should include the moral or psychological, mental or spiritual, financial, economic, social, political, and religious. Also, it is in recognition of these different facets of damages that the Civil Code identified and defined all the different kinds of damages. So, for us to remember the different kinds of damages, we have here a mnemonic, which is mental or mental. We have moral, exemplary or corrective, nominal, temperate or moderate, actual or compensatory, and then the liquidated damages. And in my report, I will be focusing on actual or compensatory. Now, since we will be focusing on actual or compensatory damages, it's important that we take the provision, which is Article 2216, which provides that proof of pecuniary loss is necessary to successfully recover actual damages from the defendant. However, no proof of pecuniary loss is necessary in order that moral, nominal, temperate, liquidated, or exemplary damages may be adjudicated. The assessment of such damages, except the liquidated ones, is left to the discretion of the court according to the circumstances of the case. So it is not every time that we base the damages to be paid by the defendant in accordance with finding proof of pecuniary loss. This is only applicable in actual or compensatory damages, and it's different in the different kinds of damages. Now, the burden of proof is on the party who would be defeated if no evidence would be presented on either side. So, he must establish his case by a preponderance of evidence, which means that the evidence as a whole adduced by one side is superior to that of the other. In other words, damages cannot be presumed in courts, and in giving an award must point out specific facts that could afford a basis for measuring whatever compensatory or actual damages are borne. So this was also provided in a case decided by the Supreme Court. Even if this is the case, it should be emphasized, however, that uncertainty as to the precise amount is not necessarily fatal, because the rationale in this doctrine is that mere difficulty in the assessment of damages is not sufficient reason for refusing them where the right to them has been established. So this was also ruled in the cases decided by the Supreme Court. In actual or compensatory damages, we have these two kinds that we can actually discuss. And we have the daño emergente, which is what we call the actual damages, and lucro cessante, or the compensatory damages. The first one is all the natural and probable consequence of the act or omission complained of, classified as one for the loss of what a person already possesses. Whereas compensatory damages or lucro cessante is for failure to receive as benefit that which would have pertained to him. So, except, of course, of the profits. Now, in further understanding actual and compensatory damages, we first try to define actual damages. And these are such compensation or damages for an injury that will put the injured party in the position in which he had been before he was injured. They pertain to such injuries or losses that are actually sustained and susceptible of measurement. So it's important to note in here that to recover damages, the amount of loss must not only be capable of proof but must actually be proven in of course an action filed before the court. Compensatory damages would be indicated by the word employed to characterize them, simply make good or replace the loss caused by the wrong. So they proceed from a sense of natural justice and are designed to repair that of which one has been deprived by the wrong of another. Also, to supplement this definition, compensatory damages are such as are awarded to compensate the injured party for injury caused by the wrong, and must be only such as make just and fair compensation, and are due when the wrong is established, whether it was committed maliciously, that is with evil intention, or not. So whether or not there was a malicious intent, it would still be going to be paid, since it's called compensatory damage. Now, it is noteworthy that we know that both actual and compensatory damages can be granted at the same time to the plaintiff as provided under Article 2200. In other words, there are two components to actual damages. In further understanding the awarding of actual damages, it's important that we also understand the purpose of the law. And its purpose is to repair the wrong that has been done to compensate for the injury inflicted. The purpose is not really to impose a penalty, but mainly to repair the wrong, to compensate what has been lost, or what has been incurred out of the injury inflicted. So indemnification for damages shall comprehend not only the value of the loss suffered, but also the profits which the obligee failed to obtain. So it can reach as far as this extent when it comes to actually paying or awarding actual damages. As to the process of awarding actual damages or compensatory damages, the basic principle for the measure of damages in tort is that there should be restitutio in integrum. This means that the amount to be awarded to the plaintiff should be that sum of money which will put the party who has been injured or has suffered in the same position as he would have been if he had not sustained the wrong for which he is now getting his compensation or reparation. This is important. The damages is measured on plaintiff's loss and not on defendant's gain. However, by way of exception, damages is measured by the benefit that has accrued to the defendant in certain cases. The theory is that the benefits derived by the defendant pertain to or could have been received by the plaintiff because only the plaintiff is supposed to profit from the activity involved. And an example would be the Intellectual Property Code, which allows recovery of amount that was earned by the defendant who infringed the right of the owner of a particular property. Because if you will be understanding the concept of intellectual property, in here, the person who created say for instance a masterpiece or whatever it is in accordance with the IPC, of course, should enjoy the benefits or the profits of such invention or such creation. But because of the damage or the injury, made by the defendant, the benefits that he or she accrued, should be the one also awarded to the plaintiff, the owner of such intellectual property. Let's now move on to damage to property. So where goods were destroyed by the wrongful act of the defendant, the plaintiff is entitled to their value of the time of destruction. So in estimating the damage to the property, it must be considered in accordance with the time of when the property was damaged. How much was the property at that time when it was damaged? It cannot be of the present if it happened years ago. So normally, the award is the sum of money which plaintiff would have to pay in the market for identical or essentially similar good, plus in proper cases, damages for the loss of use during the period before replacement. Now, in case of profit-earning chattels, what has to be assessed is the value of the chattel to its owner as a going concern at the time and place of the loss. So, for instance, the loss of a ship would require payment of its assessed value at the time and place of the loss. In determining such value, regard must be made to existing and pending engagements. Now, with respect to real property, the measure of damage for a permanent injury is ordinarily the difference between the reasonable market value of the property immediately before and after the injury. And in case of total loss, the value of the real property at the time and place of the loss must also be assessed, and such assessed value is the measure of the damage due to the plaintiff. Now, what about when we are dealing with personal injury or death? So, if the plaintiff is asking for damages for his own injury or for the death of his relative, said plaintiff is entitled to the amount of medical expenses as well as other reasonable expenses that he incurred to treat his or his relative's injuries. Courts may also award monthly payments to the person who has injured to answer for his future medical expenses, because we cannot simply say that upon say for instance, if the person already went out of the hospital, the medical expenses would already be finished. There are cases wherein the person who got injuries would also be needing maintenance medicine. So in this case, also the court may assign monthly award of monthly payments as a form of payment for the damages caused to the injury of the plaintiff. Now, in case of death, the plaintiff is entitled to the amount that he spent during the wake and funeral of the deceased. However, the expenses after the burial, because if we will be considering the culture or the tradition of Filipinos, we normally celebrate the 9th day, or what we call Pasyam, and then the 40 days also, where we believe that the person has already the person is about to move into another dimension or heaven, of course, as we know it, and or the first year death anniversary. So the expenses here would not be included. It shall only cover up to the burial of the person who died. And in addition, there's actually a formula being followed here when it comes to acquiring the amount of the damages that may be awarded to the relative of a person who died. And in here, the damages may be awarded for death caused by crime or quasi-delict include the following, and this is in accordance with Article 2206. The amount of damages for death caused by a crime or quasi-delict shall be at least 3,000 pesos, even though there may have been mitigating circumstances. And in addition, the defendant shall be liable for the loss of the earning capacity of the deceased, and the indemnity shall be paid to the heirs of the latter. So there's actually a formula here that we can check in our Torts and Damages books, of course, where the supposed earnings that can be acquired by the person who died, if you will be considering the life expectancy and then the job of the person who died, would be considered. And then if the deceased was obliged to give support according to the provisions of Article 291, say for instance, if the person is if this involves a case of legal separation, and then if the other party is being asked to support, of course, a dependent, then the decedent's inheritance by law of testate or intestate succession may demand support from the person causing the death. So the heir may be entitled to that as well. And also, when it comes to moral damages and moral damages out of the mental anguish that has been caused by the death, the heirs, the spouse, the legitimate and illegitimate descendants, so on, may also ask for the award of moral damages. Now, it's important to note that even if the victim is unknown, the fact that the victim remains in that case, and that there are no heirs that may come forward because of the identity that cannot be identified, of course, it still does not warrant the elimination of civil indemnity. So as soon as this is resolved, civil indemnity may already arise. Now, moving on, in proving the loss, the general rule is that loss must be proved before one can be entitled to damages. Because in actual or compensatory damages, as I have mentioned earlier and discussed earlier, it's important that there is a determination of the pecuniary loss. But the exception is that if the loss need not be proved in the following cases. And the first one is that in cases where there are liquidated damages, and where this have been previously agreed upon. And then also, in liquidated damages, it takes place when it takes place of actual damages, except when additional damages are incurred. So number 2 is when there are forfeiture of bonds. So this is in favor of the government for the purpose of promoting public interest or policy. The third one is loss is presumed. So next one is when the penalty clause is agreed upon in the contract between the parties. So this can also be determined in the contracts agreed upon by parties. And then the fifth one is death is caused within the contemplation of Article 2206. So just to clarify, there is a difference between civil liability ex delicto versus actual damages distinguished. So in civil indemnity ex delicto, it can be awarded without need of further proof than the fact of commission of the felony. Whereas in actual or compensatory damages, to be recoverable, it must additionally be established with reasonable degree of certainty. Moreover, on proving the loss, the general rule is that documentary evidence should be presented to substantiate the claim for damages for loss of earning capacity. So this is, of course, when it comes to acquiring or asking for award of damages when there is a personal injury or death. And the exception would be damages for loss of earning capacity may be awarded despite the absence of documentary evidence when the first one, the deceased is self-employed and earning less than that of the minimum wage under the current labor laws, in which case the judicial notice may be taken of the fact that in the deceased line of work, no documentary evidence is available. So, the second one naman is, the deceased is employed as a daily wage worker earning less than the minimum wage under the current labor laws. So, there are still exceptions. And if amount admitted by a party, even if there are no receipts and yet the amount claimed is admitted by the party, it should be granted. Now, in including actual damages in pleadings, the docketing fees must be based on allegation of actual damages, and the amount of damages claimed must be alleged not only in the body of the complaint, petition, or answer, but also in the prayer portion thereof. So, such other relief as this honorable court may deem reasonable means that this prayer may include actual damages, although not alleged in the answer, if and when they are proved. So, note that it is broad enough to comprehend an application as well as for nominal damages and even exemplary damages. So this is an important note because Article 21 of the new Civil Code cannot be used as a basis for award of actual damages. The reason is that when there is, this is because there is a pre-existing contractual relation between the parties. So this must not be included as to the basis of awarding actual damages. In as much as I want to further simplify award of actual damages or compensatory damages, in the PowerPoint that I prepared, I have included there a table which can be used as a guide in understanding these damages, the kinds of damages. So, it would be best if it would be seen using the visuals instead of me explaining it in this video. So, thank you very much for listening to my report, and I hope that everyone will be safe during this COVID-19 crisis. Thank you. I'm Carissa Marie P. Balilla, and this is my report in Torts and Damages under Attorney Noel S. Adion. Thank you very much po.